Good evening, friends. My today topic is new plea or belated plea. Can it be taken before the Honorable Supreme Court for the first time in special petition? So this is the issue. The Honorable Supreme Court has the power to entertain the new plea and belated pleas before it, depending upon the facts and circumstances of the case. This is the general apply. So there are many types of pleas, pleas of facts and pleas of law. I am going to discuss one by one each. Honorable Supreme Court has, by and large, followed the practice of Judicial Committee, of the Privy Council, and that of the Federal Court in not allowing pleas or new points of fact to be raised for the first time before it, if these points were not raised before the lower courts or before the High Court. This is the French general rule. What there are exceptions to general rules. So, in exceptional circumstances, the court has entertained a new plea on the facts for the first time. So, friends, the court stated that question, which is question of fact, could not be raised in appeal before the Supreme Court for the first time as a general rule. Question whether a special law or customs prevailed in the merger territory was one of the fact and could not be allowed to be urged for the first time before the Supreme Court. So, friends, the principle is that was laid down where the determination of question required evidence in regard to the same, it would not be fair to allow that question to be educated. So this is the principle which is developed by the Honorable Supreme Court in various case laws. Court did not allow a question to be raised for the first time whether the temple was a private one or not within the purview of Madras Act of 1949, as the said point was not taken in the pleading in the courts below. So, an accused cannot be permitted to take up a contention for the first time before the Supreme Court that the food inspector had no authority to file a complaint if the contention was not raised before the lower courts. The court held that if the accused has challenged the authority of the food inspector to file the complaint, the trial court would have gone into the same. So, as this was essentially a question of fact, so it was not allowed. As I have already told that in exceptional circumstances, the question of fact too was allowed. So, I am giving one case law and the details of that case law in which this question of fact was allowed. In Gopinath Ghosh versus State of West Bengal, 1984, supplement SCC at page 228. In an appeal against conviction and sentence, the appellant for the first time before the Supreme Court claimed that he was less than 18 years of age on the date of occurrence and as such entitled to the benefit under the West Bengal Children Act. The court held that considering the underlying intendment and the socially progressive statute, the plea of accused ought to be entertained. The court called for a finding on the age from the session court on the basis of finding that the accused was less than 18 years at that time. The accused was acquitted and the magistrate was directed to proceed as per the West Bengal Children's Act 1959. Now, friends, coming to plea of law. Insofar as pure question of law is concerned, the court would generally permit the parties to raise the same, even if the same was not raised at any stage in the proceeding. In Badri Prasad versus Nagarmal, the court allowed a new point of law to be raised for the first time before it. In that case, a question as to the contravention of Section 4, Subclause 2 of the Rewa States Company Act 1935 was raised for the first time in the Supreme Court. The court held that it was pure question of law, not requiring the investigation of any facts, and hence could be raised in the Supreme Court in appeal for the first time. Friends, it may be considered that if a point of fact which plainly rises on the record or a point of law which is relevant and material and can be argued without any further evidence being taken was urged before the trial court, and after it was rejected, why it was not repeated before the High Court. This is the new situation. The question was raised before the trial court and was not taken before the High Court. It may, in appropriate cases, be permissible for the appellant to ask this court to consider that point in an appeal under Article 136 of the Constitution. Friends, question of law, which can be decided on the material on record of the case, can be allowed to be raised at the stage of appeal by a special leave under Article 136. Question of considerable importance and might be raised in other similar suits which were said to be pending can also be raised before the Supreme Court for the first time. Constitutionality of legislation. The plea regarding the constitutionality of legislation can be raised for the first time, as declining such a plea could lead to another writ petition challenging the constitutionality of legislation, which was always open to the parties. There are so many different situations which I am discussing with you, friends. A plea as regards lack of jurisdiction can be raised for the first time before the Supreme Court. Pure question of law, which could be decided on the basis of facts on record, can be raised for the first time before the Supreme Court. There have been cases where the Supreme Court has not permitted a question of law to be agitated for the first time before it. Question that the magistrate acting under section 259 of the cantonments persona designata, and therefore his order was not revisable under section 435 or 439 of the Code of Criminal Procedure. Though the High Court may not have jurisdiction to interfere under section 435 or 439 of the CRPC, it could certainly interfere with the order of the magistrate under Article 227 of the Constitution. Now, if this point has been raised before the High Court, it may have very well be that the High Court might have considered the reference as if it was an application before it under Article 227 of the Constitution, in which case the High Court would have jurisdiction in the circumstances to interfere with the order of magistrate if it came to the conclusion that magistrate had no jurisdiction under section 259 of the Act. So in these circumstances, we are not prepared to permit the appellant to raise this point before this court at the later stage. So friends, a plea abandoned by the appellant in the High Court cannot be opened before the Supreme Court. A question which requires fresh pleadings cannot be raised for the first time in the Supreme Court. It was also held that contention not raised in the High Court or before the appellate authority or in the special leave petition cannot be entertained during arguments. Plea of jurisdiction that has not been raised by the appellant before the Commissioner for Workmen's Compensation, the Supreme Court did not allow the same to be raised. Where the appeal before the High Court was dismissed as not pressed because the matter was covered by an earlier divisional bench judgment of the High Court, it was open to the appellant to raise the point before the Supreme Court. So, friends, there are various situations, either it is of fact, either it is of law. There are exceptional situations where the Honorable Supreme Court has allowed the plea to be raised for the first time. The general rule is that the plea of facts at the later stage is not allowed and plea of law is allowed. But plea of law can be refused in exceptional circumstances, and plea of fact can be accepted in exceptional circumstances. That's all. God bless you all. See you again.